Bank customers, special types. Let us know who is a customers for bank. Now, a person can become a customer of a bank as soon as he opens an account in a bank and starts the transaction, that is, the first transaction takes place. If a person doesn't have a bank account and he makes casual transactions through a bank, he will not be regarded as a customer of the bank, even if transactions are carried by him for a long duration. Let us know understand special types customers in bank. 1. Minor. A minor is a person who has not completed 18 years of age. The minority extends to 21 years, if a guardian of his person or property is appointed by the court, see 3 of Indian Majority Act, 1875. Before 1969, in England the age of minority was 21 years. The age of minority is reduced to 18 years after passing of the Family Law Reforms Act, 1969. In other words, in England also, a person who has not completed the age of 18 years is a minor. A minor as a customers. According to Section 26 of the Negotiable Instruments Act, a minor may draw, endorse, deliver and negotiate such instruments so as to bind all the parties, except himself. He need not incur any liability under the negotiable instrument, but he can acquire rights over the instruments. However, the minor is bound by the withdrawals made by him and the bank can legally debit his account. Therefore, a banker may open an account in the name of a minor in the following ways. In the name of the minor or in the joint names of the minor and his guardian or in the name of the guardian. Person who is unable to read or write. Illiterate as a customers. Illiterate persons cannot sign their names and hence the banker take their thumb impression as a substitute for signature, and also a copy of their recent photograph. The application form and the photograph should be attested by an approved witness. For withdrawing money, he must attend personally and affix his thumb impression in the presence of an official of the bank, for the purpose of identifications. 3. Lunatic. A person who is mentally ill. A lunatic as a customers. According to Sec. 12 of the Indian Contract Act, 1872, a person of unsound mind is not competent to enter into a valid contract. A person is said to be of sound mind for the purpose of making a contract if he is capable of understanding it and of forming a rational judgment as to its effect upon his interests. It is important that he should be of sound mind at the time he enters into a contract. If a person is usually of unsound mind but occasionally of sound mind, he may make a contract when he is of sound mind. Similarly, if a person is usually of sound mind but occasionally of unsound mind, he cannot enter into a valid contract when he is of unsound mind. A contract entered into by a person of unsound mind is a void contract according to the Indian Contract Act, 1872. For a married woman. Married woman means a woman who has contracted marriage which is recognized as such by the Law of Marriage Act of the place where it is contracted. This includes a widow, a woman divorced or legally separated from her husband. A married woman as a customers. A married woman, Hindu, has the contractual capacity, if about 18 years of age, and has the right to acquire or dispose of her personal property called strana in Hindu law. The manager should make the usual essential inquiries in opening the account of a married woman. In the application, account opening form, she should fill up in addition to her name, address etc., the name of her husband, his address, and the address of the employer of the husband. Proper introduction is necessary. As a competent person, she can draw and endorse checks and other documents and these can be debited to her account. As long as credit balance is there in her account, there will be no risks, but, if loan or overdraft is to be given, the bank should ascertain her creditworthiness, her personal properties, strana, the nature of the properties held by her etc. The husband is not liable for her debts, except for those loans incurred for necessaries of life for her and her family. For partnership firm. When two or more persons, subject to a maximum of 100, carry on business to share profits and losses equally or in proportion of capitals, it is called partnership business. The Indian Partnership Act, 1932 defines partnership as the relation between the persons who have agreed to share the profits of the business carried on by all, or by any one of them acting for all. The persons are called partners and the business is called partnership firm. In partnership, the liability of partners is unlimited. Precautions while dealing with the partnership firm. He, banker, must examine carefully the partnership deed to acquaint himself with the constitution and business of the firm. He must check that the number of partners is not less than 2 and not more than 100. The account should be opened in the name of the firm, not in the name of partners. The banker can insist all the partners to join, to open the account, and must obtain specimen signatures of all the partners. The banker should take a letter or mandate containing the names and addresses of the partners. Nature of business undertaken by the firm. Names of the partners who will operate the account. If a check in favor of firm is endorsed to a partner, the banker should not honor it without making necessary inquiry. If there is a minor partner, his date of majority should be obtained to ensure that a fresh partnership later signed by him on attaining majority. 5 Joint stock companies. Precautions while opening an account. Joint stock company. He, banker, must ensure that the company, applicant to open an account in the bank, is incorporated, registered under the Indian Companies Act, 1956, so that the banker can sue the company for default or breach of contract if any in future. He has to thoroughly examine the following documents of the company. Certificate of incorporation, issued by the Registrar of Joint Stock Companies to ensure that the company, whether private limited or public limited, is incorporated under Companies Act. Certificate of commencement of business in case the applicant is a public limited company. A private company can start business after getting the certificate of incorporation. But a public company can start business only after obtaining the certificate of commencement of business issued by the Registrar of Joint Stock Companies. Memorandum of Association and Articles of Association are the most important documents, submitted to the Registrar for Incorporation. Memorandum contains the relationship between the company and outsiders, public, while the articles contain the constitution of the company. He must obtain from the applicant a copy of the resolution passed by the Board of Directors. To ensure that the bank is appointed as banker of the company. To know the persons authorized to operate the account, and to know the borrowing power of the company and the persons so authorized to borrow. If the person authorized to operate the company's account is having his personal account also with the banker must properly inquire about the checks endorsed and deposited in personal accounts so as to avoid unauthorized transfer, diversion of company's funds. Thank you.